In 1971, a seemingly innocent hiring policy cost Duke Power Company over $2 million in back pay, not because they intended to discriminate, but because their rules had a discriminatory effect. This wasn't about overt racism or malicious intent. It was about something far more subtle and far more pervasive that reshaped American employment law forever. How could a company's good intentions lead to such a costly legal defeat? We're going to unravel the curious case of Griggs v. Duke Power Co., tracing its path from a small power plant in North Carolina all the way to the Supreme Court. By the end, you'll understand how this landmark decision redefined what discrimination truly means in the workplace, and critically, how it established a legal standard that continues to catch even well-meaning companies off guard. And stick with me, because the last part of this is the piece almost everyone gets wrong about what makes a policy legal or illegal. And it's the part that decides whether your business could face millions in liability. In 1971, the U.S. Supreme Court found that a seemingly neutral hiring policy, implemented with no malicious intent, could still be profoundly illegal. This principle, established in Griggs v. Duke Power Co., fundamentally reshaped American employment law, making companies accountable for the discriminatory effects of their policies, not just their explicit intent. At the heart of the case was the Duke Power Company's Dan River Steam Station in Draper, North Carolina. Prior to the Civil Rights Act of 1964, the company openly segregated its departments. White employees worked in higher-paying divisions, while black employees were relegated to the Labor Department, where the highest-paying jobs paid less than the lowest-paying jobs in the other departments. After the act took effect, Duke Power ostensibly desegregated, but introduced new requirements for internal transfers to the previously white-only departments. A high school diploma or passing score on 2 professionally developed aptitude tests. These requirements applied even to existing black employees seeking to transfer out of the Labor Department. The problem, as the plaintiffs would soon argue, was that these new requirements disproportionately screened out black applicants and employees, even though the jobs themselves had historically been performed successfully by individuals without such qualifications. This created a significant hurdle for upward mobility. The implications of this case continue to resonate today, influencing how employers structure their hiring processes and evaluate job qualifications across industries. In 1964, as the Civil Rights Act's Title VII prohibited employment discrimination, Duke Power Company's Dan River Steam Station in Eden, North Carolina, operated under a segregated system. Black employees were confined to the lowest-paying Labor Department, which had no educational requirements. White employees, however, accessed higher-paying roles in departments like operations and maintenance. After Title VII took effect in July 1965, Duke Power implemented new hiring and transfer policies for all non-labor departments. Employees now needed a high school diploma or passing scores on 2 standardized aptitude tests, the Wunderlich Personnel Test and the Bennett Mechanical Comprehension Test. Duke Power argued these universal requirements aimed to improve workforce quality. However, Willie Griggs and 12 other black employees contended that these neutral criteria disproportionately affected black employees, who had been denied proper education under North Carolina's segregated school system. Statistics from 1960 showed only 12% of black males in North Carolina had high school diplomas, compared to 34% of white males. This disparity posed a critical legal question. Could a policy, even without malicious intent, be illegal if its impact was discriminatory? In 1964, the Civil Rights Act's Title VII prohibited employment discrimination, yet Duke Power Company's Dan River Steam Station maintained a segregated system. Black employees were restricted to the lowest-paying Labor Department, which had no educational requirements, while white employees held higher-paying roles. When Duke Power introduced a high school diploma requirement and general intelligence tests in 1965, the district and appeals courts initially sided with the company, accepting their argument of no discriminatory intent, as the new rules applied equally to all. However, the U.S. Supreme Court, in a unanimous 1971 decision delivered by Chief Justice Warren Burger, established the doctrine of disparate impact. This meant that Title VII proscribes not only overt discrimination, but also practices that are fair in form, but discriminatory in operation. If an employment practice disproportionately excludes a protected group and cannot be proven to be job-related, it is illegal. Duke Power failed to demonstrate that either a high school diploma or their specific aptitude tests were necessary for success in their higher-paying operating jobs. But what was the real cost of these seemingly neutral policies? The immediate aftermath of Griggs wasn't just about justice. It was about a profound and expensive shift for every employer in America, projected to cost businesses over $2 million by 2026. Prior to Griggs, employers believed that if their hiring policies didn't intend to discriminate, they were legally sound. But the Supreme Court's ruling created an entirely new legal burden: the obligation to prove that any employment practice causing a disparate impact was a business necessity. This meant companies could no longer simply rely on intuition or common sense to justify requirements like a high school diploma or a general intelligence test, as Duke Power had. This legal redefinition triggered a wave of expenses. Employers suddenly faced massive costs to develop and validate selection procedures, often through complex industrial organizational psychology studies. By 2026, compliance costs, legal fees from defending disparate impact claims, and settlement payouts directly attributable to the Griggs precedent are projected to exceed $2 million. This cumulative expense covers HR departments redesigning entire systems, legal teams navigating intricate Title VII claims, and expert consultants continuously auditing practices. The invisible cost of Griggs meant that a seemingly neutral rule could, and often did, bleed businesses dry. The hidden trap: why common sense now leads to lawsuits. But how did seemingly sensible hiring criteria suddenly become a legal trap? The ruling in Griggs v. Duke Power Company redefined common sense requirements as potential liabilities. Previously, a company might require a college degree for a sales position or a physical fitness test for a warehouse role, believing these were neutral. Now, such requirements could be challenged under Title VII if they disproportionately excluded certain demographic groups. The legal battleground shifted dramatically from proving discriminatory intent to demonstrating statistically disproportionate impact. Employers were now compelled to prove business necessity for any practice resulting in disparate impact. This meant showing the practice was directly job-related and essential for the safe and efficient operation of the business, a high evidentiary bar. For example, if a background check disproportionately excluded a protected class, the employer had to prove its necessity for that specific role, not just its general utility. This created a chilling effect. Many employers, rather than engaging in complex, expensive validation studies, simply removed criteria that might have a disparate impact. The question then became, who actually paid the $2 million price for this newfound legal complexity? Beyond the projected $2 million in compliance expenses, the true cost of this shift in hiring law disproportionately burdens small and medium-sized businesses. Lacking the extensive legal and HR resources of larger corporations, these businesses struggle to fund costly job validation studies. This has, in some instances, led to a reverse effect. To mitigate disparate impact claims, some employers adopt practices that avoid robust merit-based criteria rather than invest in proving their job-relatedness. For example, A local construction company might hesitate to require a specific advanced certification, even if beneficial for safety, fearing a disparate impact challenge. This paradox means Griggs, while aiming to prevent discrimination, inadvertently penalizes employers for genuinely valuable standards due to prohibitively expensive validation processes. These increased compliance costs are often passed on to consumers through higher prices or reduced services. Thus, the very people the Civil Rights Act was designed to protect may ultimately contribute to the $2 million price tag. Griggs cemented disparate impact as a cornerstone of civil rights law, but its complex and expensive implementation continues to fuel debate over its significant, often indirect, costs. Dukepower introduced a high school diploma requirement and general intelligence section, the $2 million secret. How a fair rule bleeds businesses dry. The immediate aftermath of Griggs wasn't just about justice. It was about a profound and expensive shift for every employer in America, projected to cost businesses over $2 million by 2026. Prior to Griggs, employers believed that if their hiring policies didn't intend to discriminate, they were legally sound. But the Supreme Court's ruling created an entirely new legal burden. The obligation to P-section, the hidden trap. Why common sense now leads to lawsuits. But how did seemingly sensible hiring criteria suddenly become a legal trap? The ruling in Griggs v. Dukepower Company redefined common sense requirements as potential liabilities. Previously, a company might require a college degree for a sales position or a physical fitness test for a warehouse role, believing these were neutral. Now, such requirements could be challenged under Title VII if T-section, the unintended fallout. Who really pays the $2 million price? Beyond the projected $2 million in compliance expenses, the true cost of this shift in hiring law disproportionately burdens small and medium-sized businesses. Lacking the extensive legal and HR resources of larger corporations, these businesses struggle to fund costly job validation studies. This has, in some instances, led to a reverse effect. To mitigate disparate impact claims, the Griggs decision fundamentally reshaped how employers in the United States approach hiring, shifting the focus from intent to measurable impact. While undeniably a landmark in civil rights law, ensuring that seemingly neutral practices do not inadvertently perpetuate systemic inequalities, it also introduced a complex and often costly compliance burden. The tension between the noble objective of equal opportunity and the practical challenges of implementation continues to evolve, prompting ongoing debate about whether the current framework efficiently achieves its aims without unduly penalizing employers. This video presents publicly documented information. It is for educational purposes, not legal advice. Given the complexities highlighted, have you encountered a situation where a seemingly neutral job requirement had an unexpected impact, either as an applicant or an employer? Share your insights in the comments below. For more deep dives into the legal precedents shaping our world, subscribe. And if you're curious about another case that redefined corporate liability, watch my breakdown of Palsgraf v. Long Island Railroad next.